introduce the panelists as they come to the stage. Peter Eckebert, our moderator here today. We're going to be discussing HISA, a status report, where we are now. And that has been a very fluid dynamic, as we all know, whether it's the challenges in the court or dealing with the regulations and trying to have some assistance in hindsight, giving some help to what is there now. So with Peter's help, National HBPA General Counsel, he'll be helping moderate us through the panel. First up is Pete Sakopoulos. Sakopoulos is, and this must be a typo, says he's a graduate of Tulane University, not Go Tigers. Okay, okay.
I want to tell you, I've traveled across the country, and it is a great sacrifice to be on the stage with an LSU grad. That's all I got to say about that.
Go Tigers. But Pete's become a great friend of the industry. He's become a great friend of myself with he and his family. Have the fortunate opportunity to be his guest at the Indiana Derby. So it's a wonderful, wonderful thing for him to be here to help us walk through this. Also, next up, a name many of you may not know yet, Mr. Daniel Sir. Daniel is a managing attorney at the Liberty Justice Center. Daniel is quite possibly one of the most dynamic individuals I've had the opportunity to meet outside the horse industry. But he has taken on our charge with passion and vigor that I don't think could be replicated by anybody but me. But he has grabbed the bit and he is running through it for everybody that is in this challenge with us. So I'm very honored that he was able to make the trip down from the land of Chicago to be here with us. But he's pretty much travels throughout the United States working on many similar cases to what we have, but I can promise you his focus has been with us. And then last but certainly not least, my good friend John Duviel, the General Counsel of the Louisiana HBPA, which seems like a minor piece of his job description when you consider all the things that he does for horsemen here in the state of Louisiana, but now you can add to a national stage. John also involved with and spearing the charge here with our keynote speaker that will be with us later, Attorney General Landry. They have been pushing to make sure that HISA either corrects itself or we get a new boat. So with that, I will turn it over to Peter, and let's get this party started.
Thank you, Eric. Well, we've got, we have the four of us. We'll try and split up the cases that are currently pending. There are 4 cases that are pending against HISA. The Sixth Circuit decision came down on Friday, and I'll go into that somewhat. Daniel will tell us where we are in the Lubbock, Texas, National HBPA versus Black case. And then John is going to go into the Louisiana case that's been remanded by the Fifth Circuit back to the district court, as is the Lubbock case. And then Pete will go into the case that was filed in the Northern District of Texas by the racetrack. So just to give you a quick, which everybody's, I'm sure at this stage has heard, the Sixth Circuit found HISA to be constitutional. They found that the claims that were made by Oklahoma, West Virginia, the racing commissions, the Oklahoma Quarter Horse Association, and other organizations, that the claim of non-delegation was cured by the amendment that was tacked on to the omnibus spending bill in the dark of night in December.
We're going to need, they cannot hear you. You'll need to pull that closer.
Okay. All right. Is that loud enough? Okay. Which was tacked on to the omnibus spending bill, a 4,000-page bill, and a 2-sentence, basically, amendment. The Sixth Circuit found that cured the defect that the Fifth Circuit found in the delegation area. They also found that the anti-commandeering, the other claim made in that case, was either not ripe to be heard, or that that it was not a violation of anti-commandeering. So at this stage, then, that case, what will happen next is sort of in the court of the Oklahoma, West Virginia, and the parties involved in that case as to whether or not they seek cert or what their next steps may be. And again, I'm not privy to that, but we're all waiting to see how that rolls. Our case, which was in Lubbock, is that Daniel is handling so adroitly. He can give us a sort of summary overview of what's going on there.
Sure. Well, good morning, everybody. Thanks for having me. Thank you, Eric, for the introduction. I'm glad you got it right. I have to tell you, I was on a radio show the other day, and I was introduced as Daniel Sir from the Liberty Justice League, which made me sound way more like a superhero. My 8-year-old was very impressed that his dad was part of the Justice League. So you're probably all wondering, for starters, like, what's a Justice League lawyer doing at a horseman's meeting? Right? Like, this is not my usual nerdy law school setting where I talk about these things. The first reason I'm here is because Eric asked me to be. And I have to tell you guys, Eric Hamelback, and I can say this now because he's left the room, Eric is the man as far as I'm concerned. So in my industry, not the horse racing industry, but the public interest litigation industry, the difference between a case and a law review article is a client. Right? I got lots of ideas for things that are wrong with the world. I got lots of ideas for laws that are unconstitutional. But I can't do anything about it unless there is a client willing to partner with me to bring a case. And in this case, that takes courage. Going to Mitch McConnell and saying, I think your law might be unconstitutional, I'm going to sue you, I'm going to go to court, I will go all the way to the U.S. Supreme Court if necessary. Like, that takes guts. And I want to start by saying how grateful I am to HBPA and Peter and Eric for having the backbone to do this case, because it would have been really easy to take a different path or to let somebody else lead and be the tip of the spear. I'll also say about Eric, not only once we launched this case, but as we've been doing it, I think you guys probably agree, it's been a little bit of a roller coaster. We got the Northern District of Texas, we got the Western District of Louisiana, we got the Amarillo Division of the Northern District of Texas, we got the Lubbock Division of the Northern District of Texas, we got the 5th Circuit, we got the 6th Circuit, we got this rule, we got that rule, it's enjoined, it's suspended, it's enforced. My gosh, it's been a roller coaster. And there have been plenty of weeks where Eric and I have talked on the phone every single day of the week. And that man has just a cool, calm, and collected approach that wherever the roller coaster is going, whether we're high or whether we're low, he's always asking the right questions, he's keeping a steady gaze on the future, and he's always committed to doing what's best for the industry. So that's the first reason I'm here. The second reason I am here, and why I am honored to represent all of you, and I think I can say that, to the extent that all of you are members of the HBPA, you guys are my clients too, and so I'm honored to represent you. Because I believe this case is important, not just for this industry. I know it is. But I'm here because I believe it's important for our democracy. And I don't say that lightly. I actually think this case is really important for our country and our democracy. Because fundamentally, what we are fighting about is accountability, transparency, and fairness, which are core guarantees of our Constitution to all of us as citizens. That when government exercises power in our lives, when it comes into our businesses, when it comes to our families, whatever the setting, when government exercises power, it is accountable to voters, it is transparent to the stakeholder community and the news media, and to all of us as citizens, and it is neutral, it is independent, it is fair when it exercises that power. It's not your competitor regulating you, it's the government as a fair, neutral, independent judge of what happened here. Right? Those are the principles embodied in the Constitution. And that is not the way the authority works. So I want to just read for you from the decision you guys won, the decision that NHBPA won, the decision that for law school students will study, called National Horsemen's and Benevolent Association versus Black. So here's what Judge Duncan writes. Our Constitution permits the federal government only to exercise federal power. If it were otherwise, if people outside of government could wield government power, then the government's promised accountability to people would be an illusion. Okay, so let's go to the Sixth Circuit. I think they got the application wrong, but they got the principle right. So here's the Sixth Circuit's decision on Friday. Just as it is a central tenet of liberty that the government may not permit a private person to take property from another private person, so the government may not empower a private entity to exercise unchecked legislative or executive power. Those who govern the people must be accountable to the people. Completely transferring unchecked federal power to a private entity that is not elected, removable, or impeachable undercuts representative government at every turn. So Chief Judge Sutton said. So I think he got the application wrong, but the principle is right. What's at stake in this case is important for this industry, but it's important more so for all of us as citizens, as Americans, that we're not going to let the government pick individual parts of industries and give them power over the rest of the industry. And one of the things we know about government is when government figures out a way to get around the system, it keeps on doing it, right? That if Congress can do this in this instance, we've already seen Congress trying to do it in other industries as well. And so the line that we are drawing here, the fight that we are having here, I know it's important for your industry, but it's really important for every industry, and ultimately it's important for our country because it goes to these core constitutional principles. So the third reason I'm here is because I am optimistic. I want to say that. I am optimistic about where this case is headed. And I'll tell you why with a story. So Justice William Brennan was a justice of the Supreme Court in the middle of the last century. And every year he'd pull his law clerks into his chambers and he'd say, okay, law clerks, what is the most important rule in constitutional law? And all these brilliant young recent Yale graduates would scratch their heads, and finally somebody would say, the First Amendment. And Brennan would be like, no, not the First Amendment. Somebody would say, like, the Due Process Clause in the 14th Amendment. No, not that. Brennan would say, the most important rule in constitutional law is 5. Because if you got 5 justices, you get to make the rules for constitutional law. Right? So why am I optimistic? It's because I can count to 5. Right? So I don't want to read you guys a whole bunch of Supreme Court opinions because that would be nerdy. But I will just read you a few little excerpts. So here is Justices Alito, Thomas, and Gorsuch, 3, last year. To ensure the government remains accountable to the public, it cannot delegate regulatory authority to a private entity. That was last year in a case called Texas versus Reddick. Here's Justice Alito in 2015. When it comes to private entities, there is not even a fig leaf of constitutional justification for delegating government power. Here's Justice Thomas in 2015. Because a private entity is neither Congress, nor the President, nor the courts, the vesting clauses categorically preclude it from exercising legislative, executive, or judicial power of the federal government. Here's Chief Justice Roberts in 2015. It is a fundamental principle. No branch of government can delegate its constitutional function to an actor who lacks authority to exercise those functions. Such delegations threaten liberty and thwart accountability by empowering entities that lack the structural protections the framers carefully devised. Last one for you. This is then Judge Kavanaugh in 2008. The Supreme Court has strictly adhered to the constitutional text and flatly and forcefully said no to novel policy arrangements that contravene the Constitution. Congress may not evade the separation of powers by resorting to the corporate form. Roberts, Kavanaugh, Alito, Thomas, Gorsuch. 5. I'm not going to promise you guys anything. There is no such thing as a slam dunk in my business, right? It's a lot like your business. Everything's a little bit of a gamble sometimes. But I do this for a living, and I can tell you, like, we brought this case because we believe when it gets to the Supreme Court, those fundamental principles I've been talking about are actually going to decide the day. And by the way, I could have mentioned Justice Barrett. She hasn't written on these things, but her mentor in life was Justice Scalia, who has written on these things. And I could have read off from 1998 and 1988, where he said the exact same thing. So I think we got a really great shot at this. I know it's been a long road. I know it's been frustrating. I know it's been a roller coaster. But I am optimistic when we get there at the end of the day that we're going to get to the result we're all hoping for. So I know you're also wondering, well, Daniel, when is that going to be? Right? When are we going to get there? So just to quickly end my segment on where we are in our case, I know March 27th is coming quick. And that's the day the FTC is set for the potential implementation of the anti-medication rule. So my very practical problem is I cannot sue to stop a rule that has not yet been enacted. Right? Like you can't sue against a bill pending in Congress. Like Congress had to actually pass HISA and then we could sue them. Same principle. I can't sue against a potential rule. But we have the papers ready to go. I have already been on the phone with the lawyers for the other side. We are putting the court on notice that we are going to be asking for the district court to hear our case by March 27th if the FTC approves the rule, and to ask for emergency relief to suspend it. Don't know how that's going to go. There are reasons to be optimistic that the district court got slapped down once, not going to want to get slapped down a second time. There are reasons to be pessimistic, right? It'd be really easy to just say, well, I'm just going to follow what the Sixth Circuit said and just kind of wash his hands of it. But after that, we're going to go back to the Fifth Circuit. When the Fifth Circuit issued its last order, it ordered that the case return on future appeals to the same panel, which I will tell you is not the normal course of things. But dear sweet Saint Kyle Stewart Duncan has things he wants to say on this topic, and he is going to say them again if he gets a chance. So my goal is to get back to the Fifth Circuit soon. Can't promise it'll be by March 27th that we'll get to the Fifth Circuit, but I think it will be as soon as we can. And then eventually, whether it's our case or the Sixth Circuit case, or actually both cases in common, I was on the phone with a lawyer for the Sixth Circuit case yesterday, one of the lawyers. We're going to take this to the Supreme Court. And as I say, when we get there, I am really optimistic about how it's going to go. So that's my update. All you, John. We go next.
Good morning to everyone. Our case is the case that's pending in the Federal Court, Western District of Louisiana. And while we did raise constitutional issues, we focus more on what's called the Administrative Procedure Act. And that basically deals with the time frame and the manner and method in which HISA is trying to implement its rules, the comment period, and with the FTC. Our case came in after the case that was filed in the Northern District of Texas, as well as the one in Kentucky. And it was intended to help Horseman get a stay in place in order for HISA to not have its implementation. So when we met with our Attorney General, we explained to him what was taking place to the industry in Louisiana, and he understood it completely, as well as the timetable associated with the cases in Texas and Kentucky and what would take place for that time period. So he jumped on board immediately with the help of his staff, including Brett with the Racing Commission and the Solicitor of Louisiana, Liz Murrell. And we recruited West Virginia to participate, and we did have the jockeys for a while, but that's an issue we'll just be quiet on for now. And we did file our pleadings with the court. We also had 5 individual plaintiffs who stood up, including Bernard and Ed Finasi, and a jockey, and the head of the breeders in Louisiana, and we did receive relief. And we got in place a preliminary injunction, temporary restraining order, which HISA then immediately appealed to the Fifth Circuit. And while it was pending in the Fifth Circuit came down with the decision on the other case. But prior to the Fifth Circuit issuing its decision, I had met with a bunch of affiliates in here and indicated that we could file an intervention on behalf of everyone to come under the same protection as what the states of Louisiana and West Virginia received in our federal court in Louisiana, as well as the individuals. So we filed a petition of intervention, which is of right to come in to intervene into the case, to hopefully be accepted by the court, to be put in the same position as the state of Louisiana and the state of West Virginia, which is to the effect that HISA will not enforce its rules against those parties to it until a determination is made by the court at the district level, Fifth Circuit, etc. During that process, the district court concluded that it didn't have jurisdiction because the government, through the Justice Department for HISA, as well as the FTC, had requested this emergency appeal. Nevertheless, we did file it, and it is pending before the court. Then when the Fifth Circuit came down with its, I'll call it multiple rulings, if you will, they issued the mandate. The mandate is what sends the case back to the district court, and they sent it back to the district court with the instructions to proceed with not only their case with respect to the district court case in Texas, but our case as well on the Procedures Act, which we are part of. Well, they also issued a scheduling order that said certain days have to be met, and the first scheduling order came out to saying you had to have a joint status report by February 22nd. Well, we took the position aggressively, if you will, that on behalf of all the affiliates that wanted to participate by way of intervention, as well as 4 racetracks, the Veterinarian Society, I think we're up to 5 additional states, including the state of Mississippi, who doesn't even have horse racing other than showing it through its gambling facilities, but it does support racing. So we filed an amended complaint. And what's important about that is that amended complaint not only is filed in such a way to bring in all these additional parties as direct plaintiffs, it's also designed to cover the areas of HISA that has come into effect since we originally filed it, which is going to include the medication rules, if that comes into being on March 27th, give or take a little bit. But there's other rules that have been passed since that time. So our amended complaint not only is important to the affiliates, the racetracks, the states that are now involved, the original plaintiffs, it's very important because HISA has the ability, in theory, to still enforce its rules against the other affiliates that are out there, the other racetracks that are out there, and will do it. They're hemorrhaging for cash, and there's no ands, if, buts about it. They're being financed, we believe, through the Jockey Club and different people. So be it. But the bottom line is that at the end of the day, if they are successful, we are the ones, along with the racetracks, that are going to have to fund this thing. So in order for us to proceed and to be successful, we are attacking on 2 fronts, or 3 fronts, if you will. The district case in Texas, the district case in Kentucky, and the case in Louisiana. The case that gives us immediate relief, if we're successful, is the district court in Louisiana, because it stays or stops HISA from its application. And that's what we're trying to do on behalf of the affiliates and those parties. If we are successful with that, then while they getting through the court system to ultimately get to the Supreme Court on the constitutionality issue, our case has the ability to stop HISA from being effective in implementing its rules and regulations against us, and then also preventing the funding aspect that's associated with it as well. But the bottom line is that we are in the hands of the district court here in Louisiana, and yesterday HISA filed a motion to dismiss the amended complaint, which was pursuant to the scheduling order. We have till March 27th to file a response, so the court's going to take it up sometimes in April. If he allows the amended complaint, we don't need the motion to intervention, and then after that, we'll go forward with respect to the motion for a temporary restraining order or preliminary injunction. What HISA is deathly afraid of is the horsemen. And they're afraid of the fact that by adding these parties to the amended complaint, it basically adds 25,000 horsemen. It adds them from the East Coast to up north to down south to out west. And the effect of that would be to stop HISA if the court in Louisiana grants it. So in their brief, or in their motion yesterday, which they filed, they're saying we're forum shopping, that it's not in the best interest of justice, that people that are sitting in Nebraska, or sitting in Colorado, or sitting in different parts of our country under racing jurisdictions are different than the people in Louisiana and West Virginia. They don't have the same issues. They don't have the same concerns. They're not covered with the same problems, and that they have the right to enforce HISA against them. They even went so far to say that all these other people since July of 2022 are adhering to HISA and are following its rules and regulations. Well, that's not a true statement, because the injunction that was granted in Louisiana stopped HISA's application in West Virginia and Louisiana and against the 5 individuals. But then when they did the emergency appeal, the district court was stripped of its jurisdiction. So it's not a question that they were following HISA. You had no choice at that point, because we couldn't get you any additional relief in our district court while it was pending in the Fifth Circuit. And then the Fifth Circuit spoke very loudly and sent it back to the district court and says, now go forward and prove up why you're entitled to an injunction against HISA, not only on behalf of your 2 representative states, Louisiana and West Virginia, and the plaintiffs, but for anything that is allowed pursuant to the federal rules of procedure, which includes the amended complaint, which hopefully will bring all of you in here, the affiliates, the racetracks, so that we can proceed accordingly while we await, hopefully, a favorable constitutional case. And that's where we are. It's all yours.
And we'll leave open for questions after
Sure.
Pete's done. Go ahead, Pete.
Well, thank you for the opportunity to be here today. Are we on? Everybody here okay?
Just bring it close.
Bring it closer. All right, can you all hear okay? All right. Well, thank you for the opportunity to be here today. Not on?
I don't think it's on.
All right.
Try again.
Well, I don't want to belabor this point, but before I start, I want to say something. Sitting here next to John, if you have any question about the unity at this table, you just saw it with a guy from LSU giving the guy from Tulane a microphone that works. That was really My job is to cover what is called the second Texas case. And I thought I would tell you basically who the parties that brought it are. One is Gulf Coast Racing. It is a organization that has a greyhound track that simulcasts thoroughbred racing. It is in the process of working with the Texas Horse Racing Commission to get redesignation to be a thoroughbred track. The second is LRP Group Limited. It is seeking to operate a track in South Texas and to have racing and simulcasting. Then the main plaintiff in the case is Global Gaming, which you will know as the owner of Lone Star Park track in Texas, and also whose affiliate owns Remington Park in Oklahoma. These party plaintiffs looked at the cases, especially the first case in Texas, that was brought on the non-delegation doctrine, and the arguments that were advanced there, and thought there were additional constitutional challenges. And so they have brought those in the form of an additional case that is pending in the Fifth Circuit. Thought it might be helpful to go through very briefly what the challenges are, because they're somewhat confusing in terms of how they are being presented by way of different cases. But I think as in addition to being confusing, they're very uplifting and give a lot of reason to be optimistic, as Daniel was talking about. The first is a non-delegation doctrine. We've heard a lot about this. This has been the basis of the decision of the Fifth Circuit and is part of what was going on in the Sixth Circuit. It basically says that HISA is not constitutional because it violates the basic provision in our Constitution that Congress makes the laws, and that Congress cannot delegate the lawmaking ability to a private entity. The second argument that is advanced in challenging HISA is a due process argument. It says that our Constitution prohibits one economically self-interested private actor from wielding regulatory authority over another. The third is the appointment clause, and that says that when you're appointing people to head up agencies, that's an executive authority to do that. That comes from the executive branch of our government. And that HISA runs afoul of that provision in our Constitution because these appointments are not being done by the executive, they're being done by their own committee, their own board of directors. And also you should know not only are the appointments being done, the only way to remove a director is through their own bylaws, so that it runs afoul of being able to remove somebody as well. The fourth challenge is based on an anti-commandeering argument, which says that the states are entrusted to regulate their own racing, and that the federal government should not commandeer or take away state authority to do that. And we have the arguments that are relatively newer, which is a Seventh Amendment argument that says somebody who faces a civil penalty and a monetary fine is entitled to have their case decided by a jury trial, not by an administrative law judge that is appointed by the agency. And then we have a fourth challenge, or an additional challenge, which is a Fourth Amendment argument, which is a search and seizure argument, saying that you should not be able to go ahead and have searches without a warrant or without having a judge or magistrate intervene and authorize that search or seizure. So those are the bases of the complaint that's pending in the second case in Texas. Why do I think this case is important? I will tell you by way of disclosure, I'm involved in the first case that Daniel described. In that case, in addition to the party plaintiffs that were before the court, there were two amicus, or friends of the courts, that were represented. One was the American Quarter Horse Association, the second, the NARV, which is the North American Association of Racetrack Veterinarians, who is attempting to join in John's case. So we filed briefs in that case and argued that case, filed briefs with the Fifth Circuit Court of Appeals as well. But distinct from the first case in Texas are these two arguments, the Seventh Amendment argument and the Fourth Amendment argument, which I think have a lot of traction. And I think they have a lot of traction for a number of reasons, which I'll go into. But the first thing you need to realize is that back in November of last year, when the Fifth Circuit ruled that HISA was facially unconstitutional, there was then a legislative fix that has been talked about. That legislative fix does nothing with regard to the Seventh Amendment argument and does nothing with regard to the Fourth Amendment argument. It was a pivot directed solely and directly at the non-delegation doctrine argument. That was it. So if we going forward, we look at the ability to have a jury trial, I think that this becomes very, very important because that fix does not fix the Seventh Amendment challenge to HISA. And if there is a civil penalty, and if there is a legal remedy, then under our Constitution, the Seventh Amendment to our Constitution, that should be decided by a jury. And that's the case even if you have part of that remedy being an equitable remedy. As long as there is a legal portion to that, then you should have the right to a jury trial. Now, why is this so important? One of the reasons it's important is there is a case that has been decided by the Fifth Circuit that is going to decide this case, again, when we come back. And it is the case involving a man named Jarkessi. And Mr. Jarkessi was a gentleman who had a run-in with the SEC. And the SEC filed claims against Mr. Jarkessi for fraudulent transfer of securities. Mr. Jarkessi was then placed on a track to have his case decided by an administrative law judge, the SEC's administrative law judge, just as we, up until the last change, we're going to have our cases decided by an FTC administrative law judge. So there's a lot of parallels in this case. And the Fifth Circuit said, we're not going to do that. If there is a civil penalty involved, which is a monetary penalty in many of these situations, as we know some of these, the first penalty under HISA could be as much as $50,000. And if there are legal remedies, then you're entitled to a trial by jury. That is not contained in HISA. That I believe to be a fatal flaw. I believe that is a constitutional defect that still exists and is in no way addressed by or remedied by this fix that went through. The other is the Fourth Amendment argument, which is the search and seizure. The search and seizure basically says is that searches conducted outside of the judicial process, which would be what would happen in HISA. You would be having it within an administrative forum. So a search outside the judicial process without prior approval of a judge or a magistrate is per se unreasonable under the Fourth Amendment of our Constitution. So I think that there is a real problem there with HISA in terms of trying to remedy the Fourth Amendment argument. Now, how does HISA attempt to remedy that? It does, what it does is, as you become a covered person, as we went through this whole process, as herky and jerky as it was to sign up to become a covered person, you're agreeing and waiving that right to a search and seizure. So that's the way they try to counter that, but I'm not so sure that the Fifth Circuit is going to be very impressed with that argument. And it is still one that is out there, and it is still one that is not addressed by any legislative fix to this point. So, in terms of where we are going forward, with this litigation that I'm discussing, which is the second case, we had this case was filed back in July of 2022. And there have been a number of developments since then. The state of Texas, which has been part of the first case in Texas, the first Texas case, attempted to join in the second case. And the court there said, we're not going to allow you to join in because you've already joined in the first case, so your arguments or your grievances have been heard in the first lawsuit. And that since you opted out, Texas, of HISA, you don't have any grievance or any axe to grind in this any longer. So those were the two reasons they were excluded from joining in the second case in Texas. Where are we with the litigation there? With the litigation there, the party plaintiffs, the tracts, and the parties that I've described to you have filed a motion for summary judgment. It has been pending, and yesterday the responsive briefs were filed by the FTC and by HISA. So now where we will go from here is that there will be a reply to the response, and then there will most likely be an oral argument on this, and then at some point in the near future there will be a decision as to the second case in Texas. I am optimistic based on what the Fifth Circuit has ruled in prior cases on search and seizure and on the Seventh Amendment issues that we will be successful in the second case in Texas. So where does this leave us going forward, I guess, is maybe part of what I'll conclude with, is that when you have an adverse decision or you have a positive decision, you really have three choices, and that was all pretty much bannered about, and I'm sure in emails and documents that you all received, being members of the HBPA. In the Sixth Circuit now, with this decision that was rendered, we really have three choices. We can ask for rehearing. We can ask for, which is to ask the court to take another look at it and see if they really believe the decision they rendered was correct. That, I believe, would probably not be very successful. There is what's called an en banc review, which asks for all of the judges in the Fifth Circuit, of which there are 17, to take a look at this and see if the decision is correct. That too would not be likely to be successful. In fact, nationally, these types of reviews are less than 1% successful. Or the last approach would be to seek an appeal to the United States Supreme Court, which is, I think, what is going to be done, and that's what Daniel was referencing, and I think will be the next step forward here because of these challenges. In terms of trying to get something resolved here, I don't know. As one who represents horsemen up to this point before state agencies, and I'm licensed in multiple states, I am very concerned about HISA. I'm very concerned about the due process of HISA. I am very concerned about representing my clients in a HISA system that has a very unlevel playing field with no right at all for the FTC to have to review the lower decision of the ALJ, and with only remedy left after the ALJ, an appeal to the United States Federal Court of Appeals, which is where we have been in these decisions we've talked about up here. I'll tell all of you, beat this drum before, but I think it's worth beating again. A trip to the United States Supreme Court is $30,000 to $50,000. The average person could never afford that. And you think about due process. Due process should not have a ticket that's so expensive that the average person participating in horse racing cannot afford to participate in that kind of problem if they have an allegation against them. They should not have to travel multiple states across the country to be heard on their appeal. No longer will you have the right to judicial review in the local courthouse down the road. Now you'll be going across the state. The person in Texas who has had the review now has to come to Louisiana to be heard. It's a big burden to the people who are participating in our system, something we need to consider. So I think our due process, both from a substantive and a procedural standpoint, are additional arguments that will be persuasive to the Fifth Circuit Court of Appeals. And so I will leave my review with that.
Okay, Pete, I agree with you that, in operation, HISA likely has a lot of other issues about unconstitutionality. Just the facially, the Sixth Circuit saying it was cured, I still question that. But Daniel, let me open up to you a little bit, if you could go into like FINRA and some of the other issues we talked about.
Yeah, sure. So Peter just asked me to make a couple quick follow-up points. One on John's case. So I'm actually in front of Judge Doty in a different case. It's a totally different context. They represent a teacher who is challenging a vaccine mandate. And Judge Doty is one of those judges. I was talking about people with courage. Judge Doty is one of those judges who's got a little bit of courage. And so one of the things I am optimistic about is the fact that the Louisiana case got a really good judge. Listen to Peter talk. He mentioned the various states, and John mentioned the various states coming in. I know a lot of you in the room are state racing commissioners, and I know you've probably been, frankly, pushing your state AGs. Maybe sometimes your state AG has been pushing you, and maybe sometimes you've been pushing your state AG about getting involved in this litigation. I want to tell you, as somebody who does this for a living, the partnership between states and private sector groups and groups with an ideological mission, when those all merge, it makes a case much more powerful. So the reality is, the Supreme Court takes about 1% of the cases that come to it. By comparison, Harvard admits 3.4% of students who apply. So it is harder to get a case heard by the Supreme Court than it is to get into Harvard, right? It's hard. But when you have states coming in and saying, this really matters to our rights as states, as federalism, as sovereigns, this matters to us. And you have an industry group coming in and saying, like, we're a multi-billion-dollar industry, we represent tens of thousands of people, this really matters to us. And you have groups like Liberty Justice Center coming in saying, we have a mission about what the Constitution means, and this really matters to us. When you can align all three of those things, that's how you get a case to the Supreme Court. And so having the states, for the racing commissioners, to the extent that you've been working on your state AGs to be part of this case, I want you to know it really does matter. So Peter asked me to briefly talk about FINRA. So FINRA is the Financial Industry Regulatory Authority. And oftentimes in these debates, maybe in the conversations you've had with colleagues in the industry, you'll hear this line, well, we're just doing for horse racing what Congress has already done for the financial services industry. That there's this self-regulatory industry organization, and they're just going to be self-regulatory, and there's the SEC, the Securities and Exchange Commission, and they'll oversee them, and it's the exact same model. And I'm here to tell you, it is not the exact same model. And I want to point out three particular ways in which it's not the exact same model. The first is, and perhaps the most important to the people in this room, everybody who's licensed by FINRA gets to vote on who sits on the board of FINRA. HISA, the authority, is a self-perpetuating oligarchy. They pick themselves and they pick their successors. Does anybody in this room think if there were an open election of every covered person over who would sit on the board of HISA, that we would have the same board as the board we got today? Yeah, no, not going to happen, right? It would in FINRA. In FINRA, you have classes of seats on the board, and everybody is guaranteed a voice at the table, and it is a democratic organization. So that's the first big difference. The second big difference is if enough people didn't like FINRA, The law allows them to set up their own alternative. Now, FINRA is the only FINRA, because FINRA is arguably good at what it does. But under the law, if you didn't like FINRA, you could set up an alternative. And this actually happens in other SEC industries. The exact same rule applies to like stock exchanges. Obviously, there are multiple stock exchanges that are all regulated under the same rule. And so if Texas and Louisiana and Mississippi and all these other states, West Virginia, Oklahoma, all these states we've been talking about, and HBPA, if they all wanted to get together and say, we're going to have our own national collaborative, and we're going to have racetracks and members, and we're going to regulate ourselves, and we can establish that we're a national organization that's going to be run by a credible group of people, you could set up an alternative under the SEC model. Obviously, there is no opportunity for that under HISA. HISA is guaranteed, written into law, the authority, and only the authority, will be the authority. I also love at this moment to always point out it's called an authority, not advisors, for a reason. Right? It's not the Horse Racing Integrity Advisory. It's the authority, because their job is to exercise authority. Okay, so that's the second reason it's different. It's a democracy. You can create your own alternative if you don't like it. And the third is, let's be honest about the SEC and the FTC. If you have a bunch of stockbrokers being regulated by the Securities and Exchange Commission, and they have to run their rules by the Securities and Exchange Commission, the Securities and Exchange Commission knows something about stockbroking. They know something about the industry that they're regulating, and they can exercise fair, neutral, independent expertise. Does anyone think a bunch of nerdy antitrust lawyers who wake up in the morning excited to study a Comcast merger are going to exercise thoughtful, independent judgment about horse racing rules? No, right? Like, the FTC is 5 attorneys who specialize in antitrust issues. Telecom mergers, social media, like these are the things that get them up in the morning. They put it there for a reason. It's part of the design of the law that even if you have the image of oversight, even if you have the theoretical possibility of oversight, you will never actually have the substance of oversight because they just don't care. That's not why they're there. And so even if theoretically now they can modify the rules, they won't, because they're not going to get invested in figuring out this industry that they know nothing about and that they don't care about, right? If the people who are the authority, who are the experts, come in and tell them this is the way it should be, and then they hire somebody, and that staff person says, oh yeah, no, this rule's a good rule, like they're just going to rubber stamp it, right? And so that's the way it was designed. And again, that's just very different from the SEC model, where you have the possibility of truly independent, truly expert, second guessing, checks and balances on FINRA. So anytime anybody throws that analogy at you and says, we're just doing what they did with the SEC, you tell them to call me, because it is just not true. You just lay the two statutes next to each other. It just ain't true.
John, let me ask you this. You said in the pleadings that they were making the point that you can't have this across the board because the different states have different concerns. And how does that square with the uniformity issue that this HISA is supposed to be all about?
Well, I'm going to borrow it from my Tulane friend. It doesn't. We all have the same issues. We all have the same associations, if you will, and we all come before the same groups. It could be a local state racing commission, a state racing commission, but at the end of the day, what is being done in Louisiana, West Virginia, Nebraska, Ohio, it's all the same. It's the same industry, it's the same regulation, it's the same constitution in dealing with it. And one thing that our Attorney General brought out and that we have endorsed greatly, people refer to HISA as the authority. All they are is a corporation. They are not the authority. Just because somebody labels them as an authority doesn't mean that they are the authority. And what they're trying to do is conquer and divide. They take certain portions of the East Coast and they carve them a certain way. They've carved the jockeys a certain way. while the rest of us are unified, represent a large group of people, a large part in our industry, from Texas to Kentucky to Texas again to Louisiana and up and down the Mississippi River. We are all unified together, and these rules adversely affect us all. And it's a shame because they really don't have to. Because we'll all admit it, there are some parts of it that are good. But the bad parts outweigh the good parts. And so we have no choice but to do and pursue what we're doing, which hopefully someday will get us to the table. As our veterinarian, Mr. Daniels, knows, we have to get in there and have a voice. And if we don't, we're going to get run over. So.
Pete, let me ask you this. Do you see the FTC's role, do you see people sort of bypassing the authority and trying to go directly to the FTC if they're cited for any kind of a violation? Do you see that happening, or is that not possible?
I think they're going to be forced to go through the administrative process.
All righty. I guess, Eric, that about concludes it for us, unless there's some questions from the audience that we've got time. Okay, Frank? Yeah, we have 6 minutes.
John, I understand the injunction in your case was based on violation of the Administrative Procedure Act with regard to the safety program. Now, you're adding a claim against the medication program. Is that also under the Administrative Procedure Act, or is it a constitutionality issue?
Administrative Procedure Act, plus, since we originally filed it, I forget the series, 8,000 series, I believe it was, came in after we filed our original, and then it went to the Fifth Circuit. So our amended complaint includes the 8,000 series parts of HISA as well.
Right, but it's just an APA claim.
Correct.
Okay, thanks.
Although, if I can just point out quick, one of the ways in which it's cool how our cases work together. So one of the holdings in the Fifth Circuit case was that the quote-unquote consistency review that the FTC was doing was insufficient, right? That the FTC would just say, is this consistent with the broad purposes of the act? The FTC didn't have any independent policy judgment. If no, then then they pass the rule through, rubber stamp it. And the Fifth Circuit said no, like that's not enough. You have to ask these core policy questions beforehand. Well, under the Administrative Procedure Act, if all those rules were adopted with insufficient review, which is what the Fifth Circuit said, then they were invalid, right? Like they were reviewed without sufficient oversight. They're invalid. And so our cases have actually started working in tandem in that victories in one place help in the other place. And there are victories that John has won that I'm citing in my case, for instance, about why this is an emergency and why we need relief right away. So it's actually working in sync.
Any other questions? Yeah, go ahead.
I want to thank you for being here. It was very informative and got some things clear away. My name is Tom Sage. I'm the Executive Director of the Nebraska Racing and Gaming Commission, and we're one of the parties that John talked about. John, I had one question. You had mentioned that the other side's briefing came back to exclude us, saying that we're already doing these items. Was that what I understood?
No, they filed late last night, and I really had a chance to read it completely. But one of the arguments they made is that other than Louisiana and West Virginia, where we are covered by our original ruling by the court, that everybody else that's wanting to join our case has been following HISA since July of 2022. Basically, July 1st was the sign-up date as covered horsemen, and if you didn't do it, then you get all this bad stuff that's supposed to happen to you. So they've taken the position, from what I read preliminarily, that you all are all hand-in-hand following HISA, and that's not a true statement, because you had to sign up by a certain date, and if you didn't sign up by a certain date, they were going to scratch your horses, they were going to take your license, or whatever else they claimed they were going to do. And then, remember, they pushed back on their own the 6-month implementation without any discussion. Then they came in with the horseshoe issue with respect to the horseshoes as not being the right height. They kind of create things as they go. But no, that is not a true statement that they've made. So, and we will address it.
Correct, and we'd be happy to help you on that.
Oh, we appreciate all your help.
Because of, most people or many people in this room know, Nebraska, by design, did not race after June 30th for this simple reason. So that is not a true statement.
Correct.
Thank you.
Coming to Ken Lowe for a question.
My name's Ken Lowe, Chairman of Western Racing Commission. Peter, you and I have talked on the phone once. Email, texted me twice.
Right.
I know what you told me. I want to repeat what I suggested. I'm a non-lawyer, just a business person, but a horseman. I still believe, because when I once served on the National Advisory Council for the Small Business Administration, a presidential appointee, et cetera, that this entire act is in violation of the HBPA Act of 1953. You guys, the attorneys, read it. It's there. It says you can't do what they're doing to discriminate against individuals, particularly minorities, veterans, et cetera. It's in violation. And if you can use that, I hope you do. You guys are the smart guys. You make all the money, make a lot of impress your intelligence too. Please look at the HBPA Act of 1953. It's in violation of that.
We will. We'll discuss it. Ed Martin has one. Eric?
Moving to Ed Martin.
Thank you. Thank you. My name's Ed Martin, the president of the ARCI. My question is, the states are being aggressively pursued by HISA and its enforcement agency to enter into implementation, they call them voluntary implementation agreements. Most states on the racetrack safety side did not enter into any contractual agreement with HISA. They basically had letters of understanding representing what they were already doing and to the extent that they would accommodate HISA. When you're getting involved with using state personnel and state resources, there are very legitimate issues of state governance, accountability of employees, union contracts, and all that sort of stuff. There's only one state that has actually inked a implementation agreement with HISA for the ADMC. The states are going to be under a tremendous amount of pressure that the whole thing doesn't turn into a mess. And many states are considering doing certain things for them, whether they get reimbursed or not reimbursed or whatever. My question to you is, the existence of these voluntary implementation agreements between HISA and HIWU and individual states, does that jeopardize your cases in any way?
In our case, the Louisiana case, we've now added, I might be one state wrong, I think we're up to 7 states that have want to join the case. Louisiana and West Virginia is in, and I believe there are 5 additional states, maybe 6. Texas wanted to join, but because of what was going on with this, I'm going to call it the second case, and the decision that was made for the first case when they opted out of HISA, otherwise they would have joined as well. I would answer your question like this. It's kind of uncharted waters when states have to basically sign up and really don't have any decision. In our case, it was important for our Attorney General to reach out to other Attorney Generals for them to join the case, because we take the position that it is adverse if a state does sign up with HISA, and HISA takes the position that, quote, these states are following the rules and regulations of HISA. So your question goes both ways. I don't believe in and of itself, when you see what the states are obligated to sign up to for HISA at the time period, is going to adversely affect us. Would it be better if it wasn't? I agree. But yet, we have some attorney generals that do recognize it, and I really believe had additional time been available, we'd have gotten some more states. So I hope that answers your question.
And Ed, I would add that we seem to now have three groups. We have one group, which is really one state that is all in, one state that has opted out, which is all out, and then we have this other group that's in the middle. And I will tell you, from discussions with AGs in the Midwest, there is a great deal of reluctance to pay the HISA bill because until there is some definitive answer as to the constitutionality of the legislation. Because, I don't know whether it was Daniel or John made the comment they're sputtering financially. The concern is that if these states pay in and it's determined that it's unconstitutional, good luck getting the money back. And then they're caught in a lurch in terms of how to try to finance the state program. So I think you'll see reluctance on the terms of the states in terms of paying in until there's some final decision, at least many of the states, until there's some final decision as to the constitutionality issues.
Pete, that leads directly to my question, and I think John's right that HISA is sputtering financially, but they've been unable to bill, my understanding is they've been unable to bill the racetracks and/or states since the end of 2022 because their 2023 budget hasn't been approved. Does anyone up there have a feel for where the FTC is on potentially approving? Because they put out a budget for $72 million. They revised it down to $66 million, but I believe that was based on a March 1st starting date for the ADMC, which obviously isn't going to happen. Does anyone have a feel for where we're at on that?
Yeah, so I want to start by being clear. The FTC does not approve the authority's budget. This is they phrase it in their press materials in a way that suggests the FTC approves their budget every year. And the reason I know this is actually interesting is a legal point. So totally different context, but cattle are also the subject of a major non-delegation doctrine case. And the U.S. Department of Agriculture has to approve the budget and all contracts and all loans and all investments by the Cattlemen's Board in order to use the per-head marketing funds. None of that exists in HISA. All the HISA does is, all the FTC does is approve an assessment methodology. And then once that methodology is approved, fees go out. And then it says in the law, just get a crack at this. So anytime the fees go up, the authority has to notify the FTC. And the FTC has to publish it for public comment in the Federal Register. But the FTC cannot do anything, right? So if all the public comments come in and say, this fee is unnecessary, this fee is going to, put me out of business, whatever, the FTC has zero authority to act on the comments. They just collect them. So practically what I'll say is, from the conversations I've just kind of had informally with the other side, my impression is, they're waiting for that March 27th date, and then if the order goes into effect on March 27th, the bills will be in the mail on March 28th. That is my guesstimation based on what I've watched.
Okay, we have time for one more question. I'm moving to Danielle Barber, Executive Director of Trail.
Well, my question is kind of back to the uniformity in the voluntary agreements. If we're all supposed to follow the statute and everything, why are there voluntary agreements? And why would anybody sign them is my question.
So here's the other point I will make about uniformity that y'all can just log in your brain for the next time you have this debate. Uniformity should exist not only across jurisdictions, but also across time. They always talk about uniformity, and it's always uniformity across jurisdictions, but it should also exist across time. Think about the fact that we're going to have some races run this year under one set of rules, and we're going to have, like, if they're being run right now, and they're going to be qualifying races for future races, points races, right? And then after March 27th, if the rule goes into effect, you're going to have a different set of rules, right? And then both of those horses are going to show up at the Kentucky Derby or name your major race later on in the season. And they'll have had different horses running on different points races collecting their permission slips into the Kentucky Derby. So on the one hand, the authority is just pushing, pushing, pushing. We have to do this as soon as humanly possible. We don't have any of the testing contracts in place. We don't have enough veterinarians to run these things, but it's got to happen right away. Like next time somebody says that, just ask them, what about uniformity across a season? Can you imagine if the NFL changed the rules in the middle of in the middle of the season? And like, oh, some teams are going to get into the playoffs and other teams aren't, based on whether or not they had enough wins before the rules changed? Like, that'd be crazy. But that's exactly what they're trying to do by rushing this through by March 27th. So that's my uniformity rant.
Thank you, gentlemen. Appreciate that. If I could get everybody to give them a round of applause, we appreciate it. So in the interest of time, we are going to try to move quickly into our next panel discussion. And all of these gentlemen will be around for a little bit longer. If there's some more specific questions anybody wants to ask, feel free to do so.